Good afternoon. I'm going to call this meeting to order. The Legislative Commission on Data Practices is called to order and a quorum is present. We do need to approve the minutes from January 11th of 2024. Would either Representative Scott or Representative Niska like to? Okay, thank you, Representative Niska. All those in favor say aye. Aye. Opposed? All right. Well, as we will all recall, our last meeting was both interesting and long, but we kind of ate into a little bit of Representative Niska's time. And so we are going to hear that bill first. So please go ahead and take your seat and introduce yourself and go ahead and present your bill.
Thank you, Chair Westland, and I hope you bear with me. This is actually the first, I've never done a bill presentation before, so I appreciate you hearing this bill. It's not a very long bill. It adds 2 words to a statute, but it is a pretty important bill, and it's a bill that's part of sort of the interbranch dialogue that we as a legislature have with the courts sometimes, where the courts, the legislature passes bills and the courts try to interpret them, and sometimes, respectfully, sometimes they get it wrong in terms of what the legislature meant. And I think this is one of those instances where they did get it wrong, and they got it wrong in a pretty important way, and in a way that really undercuts the balance that the Minnesota Data Practices Act strikes between the exceedingly important interest in transparency and accountability of important government roles, in this case, the important government roles played by the Attorney General's office, and the privacy interests, especially surrounding individuals, that we have written into the provisions that protect private data on individuals. And I did asked to be put into the packets, the Energy Policy Advocates versus Ellison opinion from the Supreme Court, and thank you, Chair Westland, for including that in the packets. This is a Supreme Court decision that I think every legislator and every legislative staffer should read, frankly. It's very interesting and educational about the ways in which we pass words over here. We look at words and we throw them out into the world, and then lawyers and judges pick them apart, and sometimes pick them apart in ways that we don't necessarily anticipate. So in particular, pages 20 through 22 of the majority opinion are very interesting in the ways in which the Minnesota Supreme Court majority, a 4-3 majority, looked at the fact that in Chapter 13.65 we use private data on individuals, but then we say just data, where in other places in the statute, private data on individuals is defined again using the term data on individuals. I don't think that was an intentional decision by the Minnesota legislature, but the Minnesota Supreme Court and the lawyers involved, some of the lawyers involved in that case, made that argument, and 4 members of the Minnesota Supreme Court agreed with that argument. And so there's a discussion on pages 20 through 22 of the majority opinion that I think is very interesting. And I think ultimately Justice Thiessen, former Speaker Thiessen, had the better of the argument in terms of what we as a legislature meant and why we meant it. In the first page of his concurrence and dissent, he says, I conclude that the categories of data identified in section 13.65 subdivision 1 may be withheld from the public only when the data pertains to individuals. Put simply, I find it hard to understand how data can be private data on individuals when it is not data on individuals. Why would the legislature have used the word individuals if it meant for section 13.65 to reach data that was not on individuals? Only a lawyer would take delight in pondering that question and reaching the result the court reaches today. Other Minnesotans will be scratching their heads. And I was also left scratching my head. And I think that as we look at the broader context of the Minnesota Data Practices Act and the way it was presented by the Department of Administration here in the first meeting of this commission, it really doesn't make sense. And so my bill is very simply adds the words on individuals to 13.65 again, to make clear that it's only data that implicates the privacy rights of an individual person that would be classified as private data on individuals. So it attempts to bring this back into harmony. I appreciate that Representative Scott has also co-authored this bill. I don't think this should be a partisan bill. This is a sort of a common sense way to bring this entire statutory scheme back into balance. Other investigative bodies, every county attorney's office, for example, has to, cannot conceal the data involved from inactive investigation. So right now, under current law, there's a difference between the standard that applies to the Attorney General's office and that applies to really every other investigative body or policymaking legal body in the state of Minnesota. So this is really just a way to bring those back into balance. And I would stand for questions, or if you'd like to go on to testimony, however you'd like to proceed. Thank you.
Do any members have questions? Representative Scott?
Madam Chair, thank you. Representative Niska, thank you for bringing this really common sense change. I remember a few years ago in the legislature, we had a Timber J decision that was where the courts also got it wrong, and Representative John Lesh at that time, brought forth an amendment, basically sending the same message is that, yeah, what we have in statute, we really meant as a legislature. And I see this as sort of the same thing as like, yeah, this is really what we meant. It's the plain meaning, the plain reading of the word. So I don't think, just as the Timber J issue was a bipartisan change, I think this is something that should be a bipartisan change because it sheds sunlight in a very important area. And regardless of who sits in any office in this state government, they ought to be held to a standard where sunlight is given where needed. And in this case, I think that the courts got it wrong. And, when he was Representative Thiessen, I remember him doing a stint or two on the Civil Law Committee, and he really watched the data practices stuff pretty closely. I was always sort of amazed by that because he, around here, was kind of known in the Health and Human Services world and some of these other things, but it seemed like he really did pay close attention to this subject. So I think his opinion was spot on. So I'm just looking forward to hearing from the testifiers on this. Thank you.
Any other questions or comments? I may have a question or two. Any questions? Okay. So I guess my first question is, Representative Niska, have you had any conversations with the Attorney General's office about this issue and attempted to work with them to sort of try to resolve what your concerns are and what their concerns are?
I have not. They haven't reached out to me. I haven't affirmatively reached out to them either. I did, I think there's some interesting points worth discussing further in the written testimony that the Attorney General's office presented in terms of, are there whistleblowers or things like that should be protected? The problem with, those types of incidents in the current legal landscape is that under the rule, the secrecy rule that now prevails in Minnesota, it's not just, whistleblowers, it's not just small family farms that are drawn into this rule. It's, potentially the largest trade organizations, it's any big organization that might be influencing the Attorney General's office behind the scenes. And it's, not a rule that just applies to this Attorney General. It will apply to the next Attorney General as well. And so you can imagine situations where, big companies or big trade groups or something are influencing the Attorney General's office to go after certain competitors in the marketplace, and we as the public would be left completely in the dark. So that's the concern I have. But in terms of, have they reached out to me and had other conversations on the side? That hasn't happened yet, no.
Okay. I guess, so one of my questions also is, I think that there's a recognized deliberative process, I know certainly on the federal level, and there's a similar deliberative process with the Attorney General's office. My understanding is part of the protections is to allow for the Attorney General, whoever that may be, to be getting information or advice. How does this impact that deliberative process? Is that afforded protections under your proposed bill?
This bill wouldn't affect, for example, the provision that we have in the Data Practices Act protecting privileges, that generally imports privilege law into the Minnesota Data Practices Act. The only effect it has is that the types of data here that are defined as private data on individuals would have to actually implicate the privacy right of a natural person in order to be classified as private data on individuals. And given the type of, put into the box that we normally in the Minnesota Data Practices Act put data that implicates the privacy interests of a natural person. In terms of, the Energy Policy Advocates' opinion also answered some other questions about, for example, common interest privilege and things like that. Those wouldn't be affected by this legislative change. Those would still continue. What this really does is it takes that deliberative process protection and puts the Minnesota Attorney General's office on the same footing as the Hennepin County Attorney's Office or the Ramsey County Attorney's Office or, any city that also is dealing with, policy issues that implicate, attorney-client relationships and other deliberative process things. The governor's office, engages in deliberation, and the Data Practices Act, applies to some of that deliberative policy work within the governor's office. And that's, we as legislature have decided that's a good thing, and I think that's a good thing. It brings transparency and accountability to, the sunlight to the people who are trying to hold the governor accountable or the attorney general accountable. So it really puts the attorney general's office really back on even footing in a lot of ways with other agencies that are also democratically accountable.
Okay. And I guess, so I'll ask a last question. I may have some later after the other testifier, but so I think one of the concerns is if we're limiting the privacy to individuals, to natural persons, so small business, my small business is my name. Mm-hmm. Let's say I file a complaint against someone, for all practical purposes, I think if I understand your bill correctly, that my complaint would actually, because I'm a business, that my complaint would actually not be covered. And so there may be instances like this where it's a small business complaining against, say, a larger entity, and, getting back to sort of that whistleblower or some of those other concepts, I think my concern would just be making sure that there are protections in place for individuals or for small entities that may not be covered by this. And I think my suggestion would be that if this does move forward, I would just encourage you to talk to the Attorney General's office and see if there's some consensus that can meet any concerns that they have, but also maybe try to address the things that your bill is raising.
Thank you, Chair Westland. I appreciate that thought, and I guess the concern, my thought would be, or response to that would be, the concern you're addressing is really a concern about the meaning of the word individual in the Minnesota Data Practices Act, and it's not really a concern about the Attorney General's office necessarily. So I'm not sure what the courts have done with that particular question, the idea of a small business that's essentially the alter ego of a natural person. I suspect shooting a little bit from the hip here, I suspect that that would be something where the courts would say that that really does implicate the privacy interests of a natural person. The more difficult question maybe comes into play with like the idea of a family farm, which we in other places in Minnesota statutes do treat in many ways a family farm as if it were a group of natural persons. Maybe we want to think about the definition of individual here to expand to some of those kinds of concepts. But that's a problem throughout the Minnesota Data Practices Act, right? It's a problem about the privacy rights of individuals, and we should be thinking about it in that in terms of the privacy rights of individuals, not in terms of having the Attorney General's office or the way the Data Practices Act applies to the Attorney General's office be different than the way it applies to other places. But I do appreciate that concern, and that's maybe something that's worth some exploration in the future.
Great. Well, I appreciate your presenting this bill today, Representative Niska, and your thoughtful responses. I think we will move on to our second testifier, and we can follow up with you after Mr. Gamberling provides his testimony.
Hello.
Good afternoon. When you get settled, please state your name for the record, and I will just say that I encounter Mr. Gamberling's daughter frequently in the family law context, and she is an incredible attorney and a good friend, and so it's a pleasure to have you here today.
Thank you, Madam Chairman. My name is Don Gamberling, Gemberling. I always have to spell it for my healthcare providers, even though I talk to them with some frequency lately. So just a little bit more about who I am. I'm the spokesperson for the Minnesota Coalition on Government Information, which means I deal with the public a lot. We do a variety of things in the coalition. One of the things we do is, somebody asked me the other day what we did. We try and keep the world safe for the Data Practices Act. That's kind of what we do, okay? And that's why we're here today. Somebody mentioned they scratched their head when they read the opinion in the ERA case. I didn't scratch my head. I went, are you kidding me? And then I went to Representative Thiessen, who really said exactly what I was thinking, okay? So, I've been working with this statute before it was a statute, okay? The original statute was refined by a citizens committee, the citizens and government folks, and I was their staff. And that goes back to 1973, okay? And as the statute evolved, it gave responsibilities to the Department of Administration, where I happen to work, and the more responsibilities the commissioner got, the more he or she gave to me. And so over the years, I became the resident expert on the Data Practices Act. And I want to emphasize that in those years, I often worked very closely with the Attorney General's office, no matter what party occupied that office, okay? Now, we all know for the last several years it's been the DFL party, but it wouldn't have made any difference to me because I saw our role as being very nonpartisan. Because this is complex stuff. It's not real, it's real dense, and a lot of people don't want to have anything to do with it. And so what we try to do is help people, no matter what their politics were. And frankly, that's what the Coalition on Government Information still does, okay? We take a very nonpartisan view of these issues. So I want to tell you a couple things. How we got here, and what's so important about Representative Niska's bill, okay? You also have written testimony from Matt Ealing, who's the interim chairman of COGI, and it's much more detailed than I'm going to be, at least I hope so. As somebody observed, the emphasis in the Data Practices Act since its beginning was focused on data privacy, and that's associated with individuals, okay? And so in the early years of the Data Practices Act, that was pretty much its focus. In 1977, the legislature, however, got into the business of updating our old public record statute to deal with the whole subject of access to government information. But that privacy thing carried over during that process, And so what happened is the legislature created a system of classifying data, and they tied to that system of various rights, duties, et cetera, depending upon how data are classified. So in Matt Eling's testimony, you'll find a matrix that says data on individuals, and then it has the classifications, public, private, confidential. Data not on individuals has the classifications, public, non-public, and protected non-public. And so that's been built into the Data Practices Act essentially since 1979. Now to get there, in 1978, the legislature put into the statute a presumption that all government data are public, with a very broad definition of that term, okay? However, they knew that that wasn't going to fit reality because a lot of government agencies didn't treat data as public. And so they gave time for a transitional period, and they gave the Department of Administration the authority to approve what were then called emergency classifications of data. So any government agency in this state could come to the Department of Administration. We're good bureaucrats. We had a form, fill out the form, and send it in, and the commissioner would decide whether or not they should get the classification of data that they requested. In most cases, they got what they asked for. However, the end product of that was a bill that went to the legislature, okay? And as a matter of fact, that process is still in the statute. It's now called temporary classifications, and the same thing takes place. One of the agencies that submitted an application for emergency classification was the Attorney General's office. And it pretty much read word for word what's currently in 1365. Okay, with one exception. The AG wanted its data to all be not public, at least as listed in that section. And so there was a negotiation. How do I know there was a negotiation? Because I was the negotiator, okay? And we negotiated with the AG so that all that would be covered by the emergency classification was data on individuals, okay? So 1365 got that language. And frankly, what went to the legislature, along with several dozen other classifications of data from all over government, was the language that's currently in the statute, okay? So, I have to tell you that the legislature, faced with a very large bill, didn't spend a lot of time talking about everything because they'd already been kind of gone through the Department of Administration, and I think they kind of trusted us. So that's what was enacted, I think in 1979. And it just sat there for years. Nothing happened. And then in 1993, if I remember right, an individual, and part of what I love my job was the people that I dealt with. This was the president of Minnesota Smokers' Rights. I did say Smokers' Rights. His name was Archie Anderson. He went to the AG's office because he wanted to know how some of the settlement money that came from the giant settlement was being spent. Who was getting the money, how much they were getting, et cetera, et cetera. And he asked for that data. And he was turned down by the AG's office, which cited section 13.65. So there were, in his request was a whole bunch of different stuff, but part of what he asked for was the names of organizations getting settlement money and how much they were getting, okay? Now you've got a copy of that opinion. It's in your packet. Okay? And so under some fairly recent authority, the Commissioner of Administration was recent in 1994, was given the authority to issue advisory opinions about what the Data Practices Act says, okay? And so Mr. Anderson asked us for an advisory opinion. We consulted the Attorney General's office for their position, and the Commissioner issued an opinion basically saying some of the information that he wanted was indeed public, and he ought to get it. Okay? Frankly, I don't remember if he got it. I think he did. But I know for sure that the Attorney General came to the legislature because they didn't like that result. And they said, we want you to add the language that now the Supreme Court has put into the Data Practices Act, and you turned them down, okay? That was in 1996 that happened, okay? So at least the 1996 legislature stuck by the position that Representative Niska's bill is trying to take. And then nothing happened until ERA Associates asked the Attorney General for data, and then the for lack of a better word, the fracas ensued, okay? Now, to be frank, Minkoji filed, we filed, bear with me. We said we thought ERA associates, at least on the question of classification, was right. So we filed a friend of the court brief, okay? So when this decision came out, as I said, I was just kind of like, wow. Now, why is what Representative Niska trying to do important, okay? The Attorney General's office has two basic important functions. He or she is the chief law enforcement officer for the state of Minnesota, including being its chief attorney, okay? But the Attorney General's office is also an administrative office, just like all other levels of government in Minnesota, okay? And the result of this opinion, okay? Now, as the chief legal officer, and this is true of all attorneys in Minnesota, some of the concerns that the Attorney General raised in his letter to you are covered by other statutes, okay? So, Section 1339 classifies civil investigative data as public, okay? Who decides what civil investigative data is? The chief attorney acting for the government agency. So anytime the Attorney General feels he's doing something, dealing with a case, dealing with complaints of small businesses, whatever, in which he thinks that might turn into a legal action, he or she can declare that to be civil investigative data, and none of it is public, okay? Number two, years ago, the Attorney General's office came to the legislature and said, you know, we're a little worried about work product, okay? And for non-attorneys in the room, it's what the lawyer does behind closed doors when he's trying to figure out what to do with a case. And so we worked with the Attorney General's office, I did, and what was enacted was Section 13.93, which is attorney's data, which is also very protective of the work product and related information collected and maintained by any attorney in this state, okay? Who decides what is attorney's data? The attorney who's got the data. So there's considerable discretion there. Lastly, or not lastly, but Representative Niska and other people have mentioned attorney-client privilege. That also protects data, okay? And the courts so far have been pretty generous to public attorneys about what constitutes attorney-client privilege data, okay? Lastly, to the extent that the Attorney General's office participates in criminal matters, those data, criminal investigative data with very limited exceptions, while the investigation is active, are all protected from public disclosure. When there's no longer an investigation, there are also some things that aren't public, okay? So there's a whole bunch of stuff surrounding the Attorney General's ability to protect the data that's described in his letter, okay? None of those things go to the very heart of really upsetting how the Data Practices Act handles data on individuals and data not on individuals. Because I've done this for so long, and I've spent a lot of time talking to public attorneys, okay? One of these days, somebody is going to make the same argument in another situation, not the Attorney General, for this proposition. And if the Supreme Court buys that, then you have a very strange reality in the Data Practices Act, because a whole structure that's built on tying responsibilities and rights to how data are classified will essentially be destroyed, okay? So, one thing I want to comment on. When the legislature decided to take the direction that it did with the Data Practices Act, by that time there had been experience with the Federal Freedom of Information Act. And basically you rejected the way the feds, and frankly most other states, do this kind of stuff, okay? Most states and the feds essentially say all government data is public, and then they spell out very broad exemptions, okay? The broadest exemption, the one that gets the most case law, well, there's two that do. One's national security, the other one is invasions of privacy, okay? However, there's another exemption for deliberative process, okay? And again, the courts have been pretty good to government agencies for that. But that was not adopted as part of the Data Praxis Act, okay? But the kind of the equivalent for that, and the only agency in government at either the state or local level that gets something like deliberative process is the Attorney General's office. And that's because under the Supreme Court's definition or interpretation, administrative and policy matters in the Attorney General's office, none of them are public, okay? Nobody else has that extensive of, I'll call it an exemption, okay? And I think you need to think very carefully about whether or not you want to let that stand. I was impressed with the attorney who testified last week, in part because he said some of what I was going to say to you so I could save some time. You have to think carefully, because there's a partisan twinge to this issue, and I understand that. What happens if we get a different attorney general from a different political party, okay? I don't think you want to go there. I think you want the second most powerful government agency in this state, in the executive branch, to be fully accountable to the public. And the way the Supreme Court decided this case, frankly, and I don't care who occupies the office, they now are treated entirely differently than any other government official in this state. And that's not a good idea. Thank you. If you have any questions, I'd be happy to try and handle them.
Thank you, Mr. Gamberling. Any questions from members?
You'll have to excuse me. I'm recovering from pneumonia. So
Oh, no.
My voice is weird, among other things. So
You did just fine. I'm sorry to hear that you've been ill, and hope you're on the road to recovery. Any other comments or questions from members? Someone online? Okay, thank you so much for your testimony, Mr. Gamberling. Appreciate it.
thank you.
All right, any follow-up questions or comments for Representative Niska? Representative Scott.
Thank you, Madam Chair, and I always appreciate Mr. Gamberling coming and testifying because he gives such a good context to everything that we're talking about. I was really shocked. We received information from Mr. Ealing, who is also with Min-Koji. I was not aware of this opinion that was issued by the Minnesota Department of Administration back in October 28th of 1994. The Archie Anderson, I remember that name. He's from Coon Rapids, not too far from where I live. And I didn't know that he was part of this organization, but I do remember hearing that name over the years. But I just wanted to read a little bit from that opinion, which I think is it's an apples to apples comparison to why we're here today. And I apologize, I don't see page numbers on this opinion, but it says here, lastly, to the extent that corporations and other non-individuals have corresponded with the Attorney General about the preparation of this report, they're referring to this report that the AG's office was going to be putting together. The data in that correspondence appear to be public data, and unless it can be established that the data in the correspondence constitute a trade secret as defined in Minnesota Statutes 1337, the Attorney General has a duty to disclose that correspondence to Mr. Anderson. And then if you go on to, this is like the next to the last page of the opinion, it says, however, the Attorney General's response indicates that some portion of this correspondence came from corporations. Generally, correspondence from a corporation, from nonprofit organizations, or from other government agencies are not data on individuals. See the definition of individual and data on individuals in section 1302, sub 8 and 5 of the Act. It goes on to say section 1365, which is what we're discussing here today, subdivision 1B does not state that communications that are received by the Attorney General that are data not on individuals are classified as anything other than public, and absent a special classification for the data, which the legislature has to give as a special classification, the presumption of Minnesota's statute, section 1303, subdivision 1, operates to make communications received from corporations and other entities that are not individuals public data. And so I find it interesting, and I did ask some of the folks that have gone back and forth on this lawsuit, were you aware of that advisory opinion back when the case was being argued? And they hadn't seen that opinion. So I think it's really telling that was back in '94. So here we are, and I'm assuming, as Mr. Gamberling said, that Mr. Anderson got the information that he asked for. And I think the advisory opinion in this case was the right one. And these are the people that deal with the Data Practices Act every single day. They're the ones that help the public navigate, as Mr. Gamberling said, a very deep subject that can be caught in quagmire sometimes. Yeah. So my point, I guess, is just that this issue about government transparency, I hope that we can view this in a very bipartisan way. It always has been in the past. That's one of the reasons that this commission has an equal number of House and Senate and Democrat and Republicans. And so I hope that we can move forward in a way that gives credence to the Minnesota Data Practices Act and the fact that it is something that we should be very proud of in Minnesota. No other state has anything like this. And so I think we need to preserve that. We need to continue to have that balance of balancing people's privacy, but at the same time, making sure that government is transparent and nothing like this is hidden, so the temptation won't be there for any nefarious activity. Thank you.
Thank you, Representative Scott. Representative Feist.
Thank you. I've lost my voice, folks, so bear with me. It's just from talking too much. I'm not sick. So I find this all really thought-provoking, and thank you for all of the materials. I would just like to echo Chair Westland that I do think that dialogue with the AG's office would be really helpful. I've had some interesting conversations lately about just how the data practice, like the considerations and the challenges evolve over time as the way we maintain documents and the types of requests that are received change over time. And so I think that means the Data Practices Act does need to evolve over time. And I think that a conversation with the AG's office to identify what are the challenges that they're facing and the issues they're trying to address, but then also trying to perhaps bring a little more logic to our interpretation and the language in the Data Practices Act. I think all of that could be really successful and get us to the goal. Because I appreciated at the end of Matt Ealing's materials, one of the arguments just about, we do want clarity. We don't want people to come up with clever legal arguments to get around what we're trying to achieve with the Data Practices Act. So I hope that was coherent. Thank you so much.
Thank you, Representative Feist. All right, any other questions or comments? All right, Representative Niska, you get the last word.
Well, thank you, Chair Westland. Thank you, Representative Feist. I appreciate those comments. And of course, I'm open to meeting and talking with anybody. I am a first-term legislator and introduced a bill and didn't presume to reach out to the Attorney General's office, but I'm certainly open to having dialogue with anybody about this bill. I just wanted to underscore again that this bill is really about maximizing democratic accountability. It's about the values in the Minnesota Data Practices Act of trying to make sure that the government actions, the people who we as the voters have the right to hold accountable, have to be transparent about what is going on. And The Attorney General's office is very, very important office. We have passed many bills last year and may pass some more bills this year that give even more enforcement power and discretion to the Attorney General's office. And so I think as Minnesotans, we all have an interest in the Attorney General's office functioning well, but we also have an interest in knowing what's going on behind the scenes at the Attorney General's office, just as we have an interest in knowing what's going on behind the scenes in other government agencies that are treated in the same way. So I think that we want to maximize that transparency and accountability at the same time as we are considering, what it takes to make that office function as well as possible for all Minnesotans. So again, thank you very much for hearing my bill, and I appreciate it.
Thank you. And first-term legislators are awesome. Right? Right? First-term senators are awesome. All right. Well, we are going to move on now to the Minnesota Consumer Privacy Act bill, House File 2309. Representative Elkins is the chief author in the House, and he will be presenting. I just want to note, my understanding is that I believe Keir Lamont and David Staus are going to be available to answer questions, but not necessarily testify, but they may have technical expertise. But we will start with you, Representative Elkins, if you can just please identify yourself for the record, and please go ahead and present your bill.
Yep. State Representative Steve Elkins, Democrat from Bloomington. And I should note that the chair of this committee is my Senate author, so thank you. So this bill is a comprehensive consumer data protection bill. It establishes a new chapter in state law, would be 325.0, and it would govern the privacy of data in private hands as opposed to public data, which is governed by the Data Practices Act. Bills like this have now passed in a dozen other states. This particular bill is based upon what's called the Washington Privacy Act template. It was developed by Washington State Senator, now retired, named Reuben Carlisle back in the 2019 timeframe, which is when I first took this subject on. Bills based on this particular template have now been adopted in 11 other states. 8 of them passed in 2023, 4 of them in red states, 4 of them in blue states, including Texas, which passed the bill unanimously in both chambers with GOP authorship in both chambers. The House author, Giovanni Capriglione, is, I would consider, a good personal friend of mine at this point. Most of the bills that passed in 2023, like mine, are built upon the Colorado and Connecticut versions of the bill that passed in 2022. So as we were drafting our bills to be introduced in 2023, those were the best templates for us to build upon. And state legislators from around the country are currently collaborating under the auspices of the National Conference of State Legislators to develop these bills, because it's important that we have a basic consistency across states. Because we understand that this is really a topic that Congress should be taking on to have uniform laws across the country, but nobody thinks that that's going to happen in the foreseeable future, and so those of us who are working on these bills at the state level feel that it's incumbent upon ourselves to work with each other to achieve as much alignment as we can, because we want to develop bills that can actually be implemented and enforced across states in practice. And when I'm done here, Heather Mortensen from NCSL will be providing about a 10-minute overview of what is the status of these kinds of bills around the country. So why do we need to do something like this? So as you're roaming around on the internet and managing your own personal online accounts, you're probably seeing notices that say something like, if you live in one of these states, you may have additional privacy rights. And you won't see Minnesota listed among those states right now where you have those additional privacy rights. So what this bill would do is give Minnesota residents the same rights enjoyed by the residents in those dozen other states that have already passed bills like this one. So what are those basic consumer rights? So under these laws, consumers have a right to have companies tell them what kind of personal data they have about them, correct inaccurate personal data, delete personal data upon request, provide a copy of the data that the company has about them on request, and to opt out of having their personal data sold, used in targeted advertising, or used to profile them. And in my bill, there's an additional protection that if their data is profiled, and we'll talk about what profiled means in a minute, that they should be, the controller should be able to answer questions about the decisions resulting from the profiling, what were the reasons why the profiling resulted in the decision that it did, question the accuracy of the data used to profile them, and to correct inaccuracies in the data used to profile them and have the profiling rerun with the corrected data. So it's one of the few provisions that you wouldn't find in other bills like this. The bill also establishes basic responsibilities of companies in Section 8 for how they handle the data. It requires clearly written privacy notices for consumers. It restricts controllers to only collecting the data that they actually need to conduct business with you and nothing more. Requires controllers to secure and protect the consumer's data, prevents the processing of sensitive data without the consumer's consent. We'll talk about what sensitive data is in a second. Requires controllers to provide a mechanism for consumers to revoke their consent, and further restricts the use of children's data. It also prohibits the use of the consumer's data to engage in discriminatory practices, as we would commonly understand that. And I put a provision in that makes the waiver of these rights unenforceable. So you can't just click a little box saying, I've read this and it doesn't matter. You have these rights whether in any case. So the structure of the bill, just in a high level, so there begins with the definitions, and there are 4 pages of definitions, and the definitions are very important because legislators in the different states that have been working on these bills have taken great care to keep our definitions aligned. If you were going to dive into the bill, a couple of the roles, or the definitions that are most important are those related to definitions of the role players, so consumers, that's you and me. Controllers, or the companies or other organizations that are creating the data and managing it. Processors are organizations that might take the controller's data and process it. Think of a mail order company or a fulfillment company that's doing work on behalf of a controller. There's a class of definitions about categories of data. So there is personal data, which is the name implies data about you and me. And sensitive data, and this is important because consumers have additional rights when it comes to personal data, or sensitive data. So sensitive data is data about race, ethnicity, religion, health status, sexual orientation, or citizenship, any kind of biometric or genetic data, data about children, and data about specific geolocation. And in my bill, I've defined it that specific geolocation data is data that's accurate enough to determine your street address. There are a third category of definitions about things that can be done with data. One of the more important ones is profiling. Think of profiling, archetypical example of profiling is like your credit score. So a model is being run to determine your credit score. The same models today might be being used to determine whether you get a job, an apartment, what your insurance rate is going to be. So the concept of profiling is a very important one. This definition of what constitutes a sale of data is important, and the definition of targeted advertising is also very important. The only place where I have got a variance from the kind of standard definition is sensitive geolocation. In most states' bills, there's an arbitrary 1,750-foot circle drawn around a theoretical point. I am a transportation policy wonk. I've been working with locational data my whole adult career, and I don't actually think that definition is either enforceable or actionable or enforceable. So I've gone to what do we really care about is the addresses where we live, work, and recreate being exposed, and that's why I've defined that one the way I have. Section 4 is exclusions. Some of this sections and stuff in this section is very important. For example, there's a definition of smaller businesses, and every one of these types of bills, there's an attempt to exclude small businesses from the scope of the bill. And in this case, I'm varying from the standard definition as well, because Texas, they came up with a definition that small businesses like much better, which basically just says you're a small business if you meet the definition of a small business under the federal rules governing for the Small Business Administration. So there will be some cases in here where another state has improved upon the basic bill template, and in those cases, I am taking some of the better ideas from states like Texas in this example. In general, governments are outside the bill scope, because in Minnesota, for example, they're covered by the Data Practices Act. But if data is already covered by another privacy law, mostly federal, but for example, if data is already covered under HIPAA or the Minnesota Health Records Act, the Fair Credit Reporting Act, Gramm-Leach-Bliley, which I'll come back to in a second, FERPA, which governs educational data, the Children's Online Privacy Act, or other similar laws, that data will continue to be governed by the privacy rules in those laws instead. With respect to Gramm-Leach-Bliley, I'm still negotiating with especially the insurance companies and the banks. In many states, companies that are touched by Gramm-Leach-Bliley have been given a blanket industry exemption. And in my conversations, for example, with Representative Caprileone at an NCSL meeting last week, he cited the example of a Texas car dealership network. Think of the Texas equivalent of Luther or Walser. That was asserting that they were exempt from the bill in its entirety because they happen to have a financing arm as one arm of the organization. So I'm working with the business community to refine the definition around this so that you would be covered by either Gramm-Leach-Bliley or this bill one way or the other, and we're wordsmithing on that one right now. We've already talked about the consumer personal data rights that are in Section 6. What we haven't talked about, though, there is that there is also language in that section that about how consumers invoke those rights, including a possible universal opt-out mechanism. So you could just go into your web browser or say and do a setting that says, I don't care, what the company is, who it is. I don't want to be the subject of targeted advertising. In fact, if you're a user of Mozilla Firefox or DuckDuckGo, you can already do that today. It requires the companies to provide a convenient means to exercise the right, to act on consumer requests within a reasonable amount of time, to verify that the party making the request is in fact the consumer before acting on the request, and it requires them to provide an appeals process. Section 7 deals with it's called de-identified or pseudonymous data. This is data for which all of the personal identifying information has been stripped, or data which has been created originally with only artificial identifiers on it. This is important. In some cases, pseudonymous or de-identified data is exempt from the provisions of the bill, but I've added a provision in the bill that says, basically says explicitly that if you're working with de-identified or pseudonymous data, that data, you must not attempt to re-identify the data. We've talked about the responsibilities of controllers in Section 8. Section 9 requires data controllers to conduct an annual assessment. These kinds of assessments are commonly required in many of the equivalent federal laws, but this would require them to describe how they protect your data, and basically all of the things that they actually do to implement the provisions in the bill. The primary value of having companies do this is it requires them to think about how they're conforming with the act, and in the process of preparing the assessment, frequently they will think of things that, oh, we haven't really covered that, we need to. And so the creation of the assessment will be the trigger that causes that kind of evaluation to go on. The assessments have to be provided to the Attorney General's office on request, and because they can sometimes include information about a company's security practices, they would be considered non-public under the Data Practices Act. You do not want a company's data security policies to be out there in the wild. The bill provides for Attorney General enforcement. Of the 12 bills that have passed so far in different states this year, every single one of them provides for Attorney General's enforcement. We have an existing fiscal note for that. It will probably be updated before the session. And I've been in regular conversation with the Attorney General's office, meeting with them again this coming Friday, just to make sure that they're all clear. And I've also connected them with the AG's offices in other states. Oregon, for example, is a state where the AG's office actually led the initiative to pass the bill. And so facilitated introductions to their counterparts in other states, the people in those states that are enforcing those bills, which has been very helpful as well. The effective date I'll be changing in the bill, the way it's written right now, it said July 1st, 2024. That's unreasonable at this point. And so what I'm working with right now is that if you're a company that has to comply with these laws in other states already, the effective date would be January 1, 2025. Other organizations, such as organizations that only do business in the state of Minnesota, would have over a year to implement it. It would be July 1st, 2025. Okay. So pretty much it. So as the Chair Westland observed, I have a couple of, we're going to hear a presentation from Heather Morton from NCSL. I have Keir Lamont from the Future of Privacy Forum and Dave Stouse from the Hush Blackwell Law Firm. Also here help answer detailed questions. They've been an incredible resource to all of us who work on the NCSL Data Privacy and AI Work Group. They vetted the first draft of my bill. They've been an ongoing advisor to all of us. So if there are technical questions, especially about things that are happening in other states, between Ms. Morton and these two gentlemen, we should be able to get just about any question you might have answered. They'll be available remotely. And if we have time at the end, I always offer a 5-minute tutorial on how to set the privacy settings on your mobile phone to maximize your own personal data privacy. There are some simple things you can do here that can dramatically curtail the amount of targeted advertising you receive. And one last thing that I would like this committee to think about is that because this is so closely related to data practices, is that in some states they've created task force after or rulemakings after the fact. I think it would make sense here, because this is actually one of the most highly functional LCC committees that exists, is to put this chapter of law under this committee's jurisdiction for regular oversight as well, something for you guys to think about. I think we can go to Ms. Morton's presentation, if she's available.
Thank you. Before we do that, did anybody have questions or comments right now for Representative Elkins? Otherwise, we could also have him wrap up at the end of the witness testimony. Okay. And I failed to acknowledge, just for the record, Senator Limmer and Representative Beckerfin are participating by Zoom. So I just wanted to make sure we acknowledge that on the record. So we will now go to Heather Morton from NCSL. She is participating remotely and has a presentation for us.
Good afternoon. I just want to double check that you can hear me.
Yes.
Okay, perfect. I apologize. We set up a new room and I don't quite know how to use all the microphones in here, so I apologize. So good afternoon, and thank you, Madam Chair and members of the Commission, for the opportunity to speak with you today. For the record, my name is Heather Morton, and I cover state policy or privacy and technology issues for the National Conference of State Legislatures. And I'm pleased to provide you with an overview of the recent state privacy legislative trends for you today. Oh, and I should start the slide deck. I'm sorry. Forgot about that. Let me share my screen.
Okay.
Oh, all right. think that's there. Okay, there we go. So for those of you who are not familiar with us, NCSL is the country's most trusted bipartisan organization that serves the legislators and staff for more than 40 years. We serve all 50 states, territories, and commonwealths. NCSL is headquartered in Denver, Colorado, where we provide comprehensive and unbiased research on state policies and legislative institutions. We also have a small office in Washington, D.C., and their work focuses on ensuring that state legislatures have a strong, cohesive voice in the federal system. NCSL does not make policy recommendations, nor do we advocate certain positions to states. Instead, we promote policy innovation and facilitate communication among states, as Representative Elkins mentioned through our task force that he serves on. We do this because we believe in the importance of the legislative institution and know that when states are strong, our nation is strong. So privacy issues are a growing concern of Americans, especially as the internet and technology have made personal information more accessible, easier to collect, aggregate, and use. And as artificial intelligence continues to develop and grow, AI's need for data could put more pressure on policymakers to address privacy and security issues. And as you can see on this map, at least 40 states and Puerto Rico introduced or considered at least 350 consumer privacy bills in the 2023 legislative session. There were 51 enacted bills and 2 adopted resolutions. And today, I'm just going to highlight 3 privacy issues, and those are comprehensive data privacy laws, children's online privacy, and health privacy. Turning to the comprehensive data privacy issue, the California Consumer Privacy Act, or CCPA, gave state residents the right to know what personal information businesses collect, sell, or disclose about them, and to opt out of that sale of that information to third parties, among many other provisions. Enacted in 2018 as a compromise to stave off an even tougher proposed ballot initiative, the CCPA went into effect on January 2020. Then, after a 2020 ballot initiative amended the CCPA, it became fully operative in January 2023. Following California's lead, Colorado and Virginia enacted their respective privacy laws in 2021, and those laws went into effect in January 2023. Connecticut and Utah followed in 2022. Then in 2023, we saw a bump of 9 states, and those are Delaware, Florida, Indiana, Iowa, Montana, New Jersey, Oregon, Tennessee, and Texas enacted their comprehensive data privacy protection laws, bringing the grand total to 14 states. And as Representative Elkins mentioned, many of these privacy laws contain substantially similar provisions, and some states have drawn inspiration from one or more states when crafting their legislation. The conversation around privacy regulatory frameworks often centers around the rights of the consumer. The right to copy, access, and correct, the right to delete or transfer personal data, the right to opt out of the sale or limit the use of personal data, and the right to non-discrimination are just a few. States are now also focusing on broader data management principles like purpose and use limits, data collection minimization, and even retention disclosures. And in Virginia, controllers must limit the collection of data to only what is adequate, relevant, and reasonably necessary in relation to the purpose for which that data is processed, as one example. And some states, like Colorado, list specific processing purposes. These purposes generally still require the consent of the consumer, but some allowances are made in certain states for purposes that are reasonably compatible with the disclosed purpose. Generally, covered businesses and other entities are defined either by revenue thresholds, data volume thresholds, or a requirement that the entity does business within the state. And the states with comprehensive consumer data privacy laws have generally agreed on similar definitions of terms like controller and processor that are critical to determining the requirements for data handlers to distinguish between those businesses that determine the purpose and means of processing consumer data, which are controllers, and the businesses that just process the personal data on behalf of the controllers, which are the processors. In Florida, Texas, and Virginia, certain government entities are exempt under these laws. And many of the comprehensive data privacy states require that there be data protection or privacy assessments that document the processing, selling of data, or other activities. These assessments often focus on high-risk data processing activities, such as targeted advertising or profiling, the sale of personal data, or processing of sensitive data. Turning to children's online privacy, while some states have addressed children's data privacy concerns within their comprehensive data privacy laws, other states have chosen to introduce privacy legislation that's specific for children, going beyond their comprehensive bills and even the federal Children's Online Privacy Protection Act, or COPPA. Last year, California enacted its Age-Appropriate Design Code Act, and this act requires that a business that provides an online service, product, or feature that is likely to be accessed by children to configure all of the default privacy settings that are offered to a high level of privacy and provide that privacy information, terms of service, policies, and community standards using clear language that is suited to the age of children that are likely to access that service, product, or feature. In contrast, COPPA, the federal law, limits the collection of user data by website operators and services that are directed at children. And COPPA protects children that are under the age of 13, while California's law applies to children under the age of 18. And the California law requires that businesses complete a detailed data protection impact assessment to assess and mitigate risks from the data management practices for any of the online service, product, or features that are offered to the public, and they have to create a timed plan to mitigate or eliminate the risk before children can access that online service, product, or feature. In 2023, 8 states, and those are Connecticut, Illinois, Maryland, Nevada, New Jersey, New Mexico, and Oregon, introduced similar age-appropriate design code bills. NetChoice, which is a national trade association of online businesses, did file suit challenging the California law as facially unconstitutional and preempted by federal law on December 14th, 2022. The U.S. District Court judge on the case granted NetChoice's motion for preliminary injunction back in September 2023, and California recently announced that it will be appealing this decision. Other states have taken a different tact, instead focusing on parental consent or supervision. And many of these bills require the parental consent to create a social media account for children, and several of these bills give parents or guardians access to the content and interaction history in that child's account. Arkansas, for example, created its Social Media Safety Act that requires parental consent and age verification of the account holder. Louisiana created the Secure Online Child Interaction and Age Limitation Act that requires parental consent and gives parents the ability to initiate account supervision. And that includes the ability of the parent to view the privacy settings of the minor's account, set daily time limits for that service, schedule breaks, and offer the minor the option to set up parental notifications when the minor reports a person or issue. And then Utah's Social Media Regulation Act gives the parent or guardian access, prohibits collecting, sharing, or using personal information from the account, and prohibits a Utah minor account holder from having access to the account during the hours from 10:30 p.m. to 6:30 a.m., subject to the parental or guardian's direction. And as you might suspect, NetChoice has filed suit challenging the Arkansas law and was granted a preliminary injunction against it in August. And NetChoice filed suit challenging Utah's law in December. The age verification provisions raise their own privacy concerns, as the process may require that these businesses collect and retain additional information to verify the age of those account holders. And with more than 40 bills that were introduced just in 2023, I fully expect to see more bills focused on children's online privacy in 2024. Turning now to health data privacy, recognizing that many mobile phone applications and websites are collecting health-related data, and that these services may not fall under the jurisdiction or the definitions of who must comply with the Federal Health Insurance Portability and Accountability Act, or HIPAA, state legislators have turned to include health data under their comprehensive data protection statutes or to create health-specific protections. And with the Supreme Court's Dobbs decision overturning Roe v. Wade, possibly having ramifications for other privacy-related case decisions that followed and were based on Roe, efforts to address health and other sensitive data have increased. Enacted in 2023, the state of Washington's My Health, My Data legislation defined consumer health data to include personal information that's linked or reasonably linkable to a consumer and identifies the consumer's past, present, or future physical or mental health status. And 43 bills progressed through the 2023 legislative session, specifically focused on health data privacy, and I expect to see more this year. Now that I've summarized quickly the recent state legislative trends in privacy policymaking on this slide, I wanted to provide the links to the state legislative tracking that I maintain on consumer data privacy on NCSL's website. And I included the link to the Legislator Guide to Privacy and Glossary of Privacy Terms that was produced by NCSL's Task Force on Artificial Intelligence, Cybersecurity, and Privacy. And as I said, looking forward to the 2024 legislative session, we're seeing that states are starting to introduce legislation, and privacy will continue to generate large numbers of legislation. As I wrap up and I'm winding up, I just wanted to do a quick shameless plug for the upcoming NCSL Legislative Summit that will be in Louisville, in case you're interested in attending. And of course, I would be remiss if I didn't share suggestions for different ways that you can access NCSL's resources and participate in NCSL. And finally, thank you, Madam Chair, for the opportunity to provide the testimony on recent state legislative activities regarding data privacy, and I'm happy to answer any questions and provide additional research if needed, and my contact information is available on this final slide. Thank you so much.
Thank you, Ms. Morton. And just members, the slide deck was received a little bit late, but it is now on the LCC website, so you should be able to access it and go back at your leisure to take a look at that. Any questions for Ms. Morton? Representative Scott.
Thank you, Madam Chair. Ms. Morton, I'm curious, the 14 states have implemented such a bill, and I know some of them just did it, so we're not going to have a lot of feedback. But what kind of feedback are you getting? How are they working? And what sort of issues may have arisen that you've heard of, if you've heard of
Sure.
that, such feedback?
Really,
Thank you, Madam Chair and members. I would say that so far, as you're correct, several of the states just enacted in 2023, so their laws are not in effect yet. But looking at the experience of like California and Colorado and Virginia, they're, that they have been going through, particularly in California and Colorado, that I know that they have been going through a lot of regulatory action to make sure that they're implementing these statutes. So there have been questions that have been raised on that, and but as they have worked out, and they're going through and working those out, and on some of that, I may have to defer to Keir and Dave, that they might have a little bit more detailed information about some of those challenges in the regulatory implementation than I have.
Mm-hmm.
Thank you, Ms. Morton. And we do have either Keir Lamont or David Staus, if they wanted to try to answer that question. They're online as well.
I think Keir and I are trying to decide who will go first.
Rock, paper, scissors.
Thank you, Madam Chair. I'm happy to kind of jump in and give you the back. For those unfamiliar, I'm David Staus. I'm a lawyer and partner in Hush Blackwell in their Denver office, and regularly deal with these U.S. state privacy laws and have for a number of years. I certainly imagine, after all the information you've been provided, that you're swimming a bit with this highly technical, long, detailed bills that come out. And I'd be remiss if I don't note that Representative Elkins and the work that he's done here is really at the tip of the spear of how hard he's worked to try to get this bill across the finish line. And it really does take a champion in each state to try to get this across the finish line. And you have one with you here today in Representative Elkins. To answer the question, it's interesting. California was the first that passed its bill. And for 18 months after the bill passed, it had a right to cure provision in it. And so the Attorney General's offices were providing notice to businesses that there was violations and then working behind the scenes to resolve those violations. There's only been one public notice involving a company named Sephora in which there was actually a public enforcement action out of California. That right to cure is now going away with the amendments to the California Consumer Privacy Act. But we have yet to see more public-facing enforcement actions. Connecticut and Colorado are also in effect, and we call them the three, at least I call them the 3 Cs of state privacy law: Colorado, Connecticut, and California, that are really pushing this issue. They right now have a right to work.
Mr. Staus, we're having a little difficulty hearing you, and it seemed like you moved because we heard you really well at the beginning. So if you could maybe get a little bit close.
Better now? Is that?
That's not better?
Yeah, not moved. Well, maybe I should
That's
defer to
better.
Peter and I can try to get a headset on.
That's a little bit better. Go ahead.
Is that better? I mean, I can lean into my computer. Sorry about that. So, to cut to the chase, Connecticut and Colorado still have rights to cure right now with their bills. So they're sending out notice. The Attorney General's offices will send out notices to companies and then work with the companies to try to remedy any violations that they see. And this has been sort of the carrot and the stick approach to consumer privacy bills. Eventually, those 2 rights to cure will sunset, and that's been an issue that's been debated in these consumer privacy laws. So I say that all to say that we are still kind of figuring out exactly, how these bills will exactly work. But I think that by and large, we see Attorney General's offices that are working with businesses to try to drive compliance, as opposed to trying to just fault people for minor mistakes and things of the like. And I'll defer to Keir if he has any further thoughts.
Thank you. Any other questions for Ms. Morton? We can always come back and revisit questions as well. Our next testifier then will be Matt Schwartz from Consumer Reports, and he is also remote.
Hi there, Chair, Vice Chair, and members of the Commission. Thank you for allowing me to testify today. My name is Matt Schwartz. I'm a policy analyst at Consumer Reports. We recently discussed this legislation with Representative Elkins, and in that conversation, we talked about how we are supportive of certain aspects of this legislation, particularly the inclusion of universal opt-out controls. But we do have a few concerns about a few key aspects that we do believe deserve some additional attention before this legislation is moved forward. First and foremost, we believe that the pseudonymous data exemption in Section 7B opens up a concerning loophole that threatens to swallow the bill by preventing consumers from using their right to opt out of sales and targeted advertising on mobile devices in particular. While other states that use the Connecticut model as a baseline typically have a similar type of exemption, they usually limit it by at least allowing consumers to opt out of pseudonymous tracking. And this is crucial because tracking and targeted advertising in the mobile ecosystem relies on so-called pseudonymous identifiers, such as mobile advertising IDs. And this is precisely the type of surveillance that the bill ostensibly seeks to grant consumers more control over. So it's a little problematic that the exemption would allow vast swaths of it to continue unabated. Additionally, we do wish to mention a few other recommendations that we think would improve the consumer protections in this bill. First, the definition of targeted advertising should be broadened to include retargeting based off of data collected and transferred from a single controller to another. Second, consumers should be allowed to exercise their rights via authorized agents, as they are in many of the other state laws using the Connecticut law as a model. This will make exercising privacy rights much more accessible where universal opt-outs might not be able to reach, such as with Internet of Things devices. Finally, we suggest that the drafters remove the right to cure provision to ensure that businesses have the appropriate incentives to comply with the legislation from the outset. At the same time, we wish to point out that this bill would make a number of really important contributions to consumer privacy, particularly notable, as Representative Elkins outlined, is the bill's contemplation of a right to correct in situations where an automated system makes important and life-changing decisions. Consumers deserve to review the data that's used to make these crucial decisions and to correct that data if errors are found. We support this provision and hope that the drafters preserve it as the bill moves forward. So thanks again for allowing me to testify today, and I'm happy to answer any questions you might have.
Thank you, Mr. Schwartz. Any question? Senator Lucero.
Thank you, Madam Chair, and thank you to the testifier there. I definitely appreciate the feedback. Could, if he has the legislation in front of him, does he have a page and line reference he could give us for the first issue that he brought up?
Mr. Schwartz?
Yeah, I have the bill in front of me. I'm just doing a quick word search to find where it is. It's section 7, so if you have the bill in front of you, more accessible, you can quickly go to that section.
Yeah. And Madam Chair, I would observe that both Mr. Schwartz and Mr. Staus caught that first item, and I'm going to fix it.
Okay.
Madam Chair?
Yes.
I
Mr.
believe and I appreciate Representative Scott's words as well. It looks like it's page 14, line 20.
Page 1420 is the line.
Thank you.
Any other questions for Mr. Schwartz? All right, thank you, Mr. Schwartz. We now have Andrew Kingman, who's State Privacy and Security Coalition, also participating remotely.
Hi, good afternoon, everyone. Can folks hear me okay?
If you could speak up just a little bit more loud.
Sure. Let me just put my microphone audio a little louder. Okay, let's try that. Is that a little bit better?
That's good, thank you.
Okay, great, fantastic. Good afternoon, everybody. Seems like just a week ago I was in that room, because it was. My name is Andrew Kingman. I represent the State Privacy and Security Coalition. We're a multi-sector coalition working in all of these states on comprehensive and other state privacy proposals. I also have a background as a compliance attorney in the privacy space, helping companies work through various state privacy laws and regulations. First, I just wanted to say, we appreciate the sponsor's work over the years. He's certainly been a leader in this space, in the state privacy and world. And, our hope is that we can get to a place this session where his work is reflected in statute. We're in communication with him. I anticipate continuing to work with him on this. Our concerns at this point, although I do understand there may be amendments forthcoming, so would qualify my remarks with that. But our concerns at this point do stem from deviations from the states which have passed this framework, which would have significant compliance impacts on companies in a number of cases, really without necessarily clear benefits to the consumers. So the representative mentioned data protection assessments. These are provisions that are really almost entirely uniform across the states other than California that have DPA requirements. And we would, we'll continue working with him, but would want this process to be uniform across all of the states. This bill, like Colorado, would require processors to undergo audits instead of independent assessments to demonstrate compliance with their contractual commitments with controllers. We believe that there's a significant cost and process difference there without much benefit. And again, that's a case where Colorado is actually a bit of an outlier. And then the privacy policy requirements, there are some sort of unique requirements there. Again, these are documents that we think serve consumers better the more uniform they are. And so would want to see an avoidance of having to have a bespoke privacy policy just for Minnesota residents. We do have some concerns around the precise geolocation definition that currently exists, and would want to see the definition of targeted advertising conformed to other states. But again, we're continuing to work with the sponsor. We appreciate his work. We're hopeful that we can get to a place of moving this forward this session here. And I'm happy to take any questions.
Thank you, Mr. Kingman. Any questions or comments for Mr. Kingman? All right, I believe that was the last person on our list. Representative Elkins, would you like to bring us home here? Respond to any of the comments? Or...
Questions?
Okay. Of course. Yep. Sorry. So Representative, that's fine. Representative Feist, go ahead.
Thank you, Madam Chair. I just wanted to thank Representative Elkins for his hard work on this important bill. I'm a co-author, and I think this is an important issue, and having worked on other consumer privacy legislation, it's very wonky. It's hard to build movement around it and excitement, and the devil is always in the details. So I want to thank you for diving into the weeds. It's really interesting to me just reading through the materials how, one of the letters from a group of digital advertising allies talks about how consumers want to share all of our data and get things for free. And maybe that's true, but we should get to make that choice. And instead that choice is being made for us. And I know that the Consumer Reports have some amendments they'd like to see, but I liked the initial comments they made in support of this legislation, talking about universal opt-outs empower consumers and make it easier to manage the otherwise untenably complicated ecosystem of privacy notices, opt-out requests, and verification. And I know from working on the Student Data Privacy Act that the question about opt-out versus opt-in was really a big point of contention. And I just want to support you in your effort to put the power back with the consumer. And it might very well be that we want to share our data because I want to get that targeted advertisement, but I should get to choose. And as technology gets more and more sophisticated, we're being manipulated in ways that we can't even imagine. And we should have that power rather than it being done to us. So thanks. There's a lot of interest here. I don't think any of them are wrong. I don't think that the interests of business are there's just intention with one another, and we need to just consider all of the implications and move forward. I think this is really urgent, important, so thank you.
Well, thank you. And by the way, Mr. Lamont is our expert on universal opt-out, if he wanted to make a comment on that. If he's... There he is.
Thank you, Pierre Lamont with the Future of Privacy Forum, based in Washington, D.C. My organization reads and takes a comparative analysis of various consumer privacy laws and bills at the federal level and increasingly these days at the state level. As Representative Elkins mentioned, we are at about 14 or so state privacy laws of this kind of similar scale enacted so far at the state level, 5 of which are currently in effect. At this point, about 7 or so of those bills provide for the ability for individuals to set what is called a universal opt-out mechanism in their device that invokes their certain privacy rights on a default basis. As they visit different websites, as they browse the internet website by website, individual privacy rights will be automatically invoked, and that eases the burdens of privacy self-management. No longer would individuals have to go web page by web page, finding individual privacy controls and exercising them on a case-by-case basis. And just noting that this bill does provide for that pro-consumer tool.
Thank you for that response. Appreciate that. Senator Lucero?
Thank you, Madam Chair, and thank you, Representative Elkins and others, all the testifiers. This is an important topic, and it's, as I'm considering this legislation and other legislation that we've had in the past and still being discussed for the future, the question I always ask is, who owns the data? Whose data is it? And my default, we've heard the word default here many times today, and it, in my opinion, it is the individual. It is the individual. So that's why I appreciate this legislation. Again, it's not perfect, but that's why we're here, is we're working to try to refine this. And as Representative Feist just said, there are no, these different voices, they're not wrong. They're all contributing to this important conversation. I don't want to sit here and nitpick different things, but just a handful of suggestions or things to consider as we're going forward here. Let's see here, on line 2.8, this is in regards to biometric data. It includes, part of the definition is automatic measurements. And I'm thinking to myself, well, why? Why? I guess biometric data is, if you were to eliminate the word automatic from that definition, it's still, everything else is true in terms of what is biometric data, but why does it have to be automatic? Again, I'm just thinking more comprehensively. Then it goes down on line 2.12 and 2.13, it excludes or does not include digital or physical photograph. And I'm thinking to myself, there's a lot of technologies now with laptops and phones that have the facial recognition, and perhaps having that exclusion may have some unintended consequences. I'd be curious what the reason was with some of the other states and in the conversations. And these are not questions to answer now. I'm just throwing these out there to put on the record. Because again, facial recognition is involving a digital photograph or capture of one's face. Then the next line, 2.13, an audio recording, actually just last week was probably the third or fourth time now calling up a bank, and through their automated systems, they're offering me the opportunity to do a voice recognition for future authentication. So if you're specifically excluding audio recordings, clearly audio recordings are being used here, and it is a biometric, and it is something that apparently is on the horizon, or it's already being adopted. And by the way, I've always declined that opportunity to have them capture my voice for authentication. Then the next one is looking at the definition of authenticate, which is on line 2.4. So when it comes to cybersecurity or protecting information, there's the principle of AAA, which is authentication, authorization, and then accounting. And so when I look at the definition here of authenticate, it begins to blur the line, I think, with authorization. It's trying to, or it reads, in being made by the consumer who is entitled to exercise such rights. Well, the entitlement of exercising rights is authorization. And so just being a purist here for the definition of authenticate would be proving one's identity. After the process of authentication has occurred, then based on the authentication, authorization is established. And the authorization is which rights are established or what privileges are granted. And so that I'm just throwing that out there to maybe separate authenticate from authorization. And then when I look at line 2.17, the definition of consent, it gets in. So again, being just the legislator purist here with definitions, the word consent should be just a definition. But then getting down to like 2.23, it starts to blur, it adds into the definition prohibitions. Thou shalt not do X, Y, Z. And that should be separated out, at least in my opinion, from the actual definition. And the prohibition or allowances should be, in other places in the bill. And then generally speaking, we've heard it in the age-appropriate design, and then even now, in regards to the geolocation, and this is on 4.26, we really do need to hammer out what is something that maybe we could use across the board for many of these different pieces of legislation. and appropriate radius or specificity when it comes to geolocation where it does become privacy invading. Is it, I think the other one was a quarter or 0.25 of a mile radius, something like that.
It's usually 1,750 or 1,850 square feet.
So, okay, and then here you're defining it as an address, or a postal address or street address. And again, I just think it's something we need to chew on. What is that? Is it a radius? Is it a city? Is it a zip code? Is it something like that?
So-
But we're continuing to see this, so
Yeah.
it's just throwing that out there. And then the last thing I'll just throw out there for us to chew on is on line 4.21, when it comes to personal data. I see that the definition or many of the different things that are enumerated here they overlap with the human rights statute of protected classes. And again, I don't have an exhaustive list, and I'm not prepared to throw other things out there. But I know there are other things that many consider personal. And I don't know if they need to be added in here, or maybe we need to not be so specific, and if there's another generalized answer. But, just off the top of my head, I'm thinking like financial data, right? I consider that very personal. And again, I don't know if that would be applicable here or how we would do that, but maybe political affiliation or group membership associations or, things like that. So there's other attributes that are personal that are not here that, again, maybe we need to consider. So thank you, Madam Chair. And again, thank you, Representative Elkins, for this effort.
Thank you, Senator Lucero. Go ahead, Representative.
I can respond to a couple of those things. So on the question of data ownership, we've talked about this one, and you know that I kind of agree with you. So when I was first doing my research on this bill back in like 2019, I went for one of the first people I talked to was a guy named Bill McGivern, who's a law professor at the University of Minnesota, who has literally written the textbook used in 20 law schools around the country, on data security and data privacy. And one of the things that he pointed out to me early on is that one of the big differences between the American approach to this topic and the European approach is that in general, the European approach is that companies only have the right to do with your data what is specifically authorized by law, whereas in the United States, the common law has been that companies are allowed to do anything with the data that is not prescribed by law. Now, neither of those approaches actually directly addresses the question of who owns the data. But all of the stakeholders who I talk to, including very progressive organizations like the Electronic Frontier Foundation, said, Steve, this constructive ambiguity is kind of working. Don't go there. So, though I think we may end up having to go there. So, as I said, I do a lot of work on locational data privacy. I have a bill that would establish mileage-based user charges, for electric cars that don't pay gas tax. And so I've had to do a deep dive into this kind of stuff. And first thing I get asked in that context is, does this mean you're going to have to put a tracking device in my car? And the answer to that is, first of all, the good news is that no, you don't have to. Wouldn't have to put a tracking device in your car. The bad news is because it's already there. So every car rolling off the assembly lines today comes equipped with a computer that has a very accurate GPS and a cellular modem, and the auto manufacturers are regularly on real time sucking that data off of your car and into the data warehouse. So it's already there. And, they'll sell it back to you if you have a new car and you have like the Toyota app or Ford Pass or one of these things. They'll rent it back to you, for like $10 a month. You can actually see the data about your car. But some of the manufacturers, Toyota most notably, have been asserting that they can do this because they own the data. So if we start seeing more companies asserting that they own the data, this may be a place we have to go. So, so that one, stay tuned on that one. If you want to offer an amendment to do that in Senate committee, go for it. So I told Nick, do not print this. But is this on the page? Okay. To make sure I was, aligning as close as practical to what's going on in other states, since my bill was largely modeled after the Connecticut and Colorado bills, I actually went through and did a cut and tape and laid out for each section of the bill, my language versus the Colorado language and the Connecticut language. So for all of these definitions that you're wondering about, you can go back into the definition section at the front here and see what the definition is. So a lot of these definitions are, from the previous bills. They've been vetted in numerous states and adopted in numerous states. And the business community has been consistently telling us all, try and stay as consistent as you can with the definitions. So, but go back and look at what like the Colorado and Connecticut definitions are. And if you've got suggestions for improvements, I'll work with you on some of those. But we got to stay, pretty close to where the bill is right now. So the one where I have an issue with the geolocation is that how do you know if you, the way I look at it, say I've got a spreadsheet. And the spreadsheet has two columns on it, one for trip origin and another one for trip destination. So where does my trip start? Where does my trip end? How do I know, what kind of a value can I put in the trip origin and trip destination fields that I can be confident are or not within 750 feet of a theoretical point? I couldn't think of a way to do it. And if, say, you were, in presenting the data, we're doing a random offset of this is the real point, I'm going to report it is at this point 750 feet away. All somebody would have to do is request that information 3 times, get 3 points. Then all I have to do is draw a circle around those 3 points, and the place where they intercept is the true point. So I spent a lot of time on this one talking with the GIS experts at ESRI, and they kind of said, well, Representative Elkins, we kind of think you're on the right track. You're right about that stuff. And I think that, why, like the online advertising industry is, doesn't like that definition. Well, here's, again, another story is coming on here. How many of us used online digital advertising in our campaigns in 2022? Okay, yep. So before I signed up, this is the first time I'd done it, I asked the vendor, well, how do you target the ads? Okay, so I said, well, basically the way it works is that, we all have our party databases where we, figure out which voters we want to reach. You just have to pull a file off of that database in CSV format that has the names and addresses of the voters you want to reach and send it to me. And then I have a partner vendor over here that has mapped all of the devices in the world to their addresses based on where they are, overnight, or where they spend the day. So if you're in the habit of, say, checking the weather that when you get up first thing in the morning, then it's likely that the weather app, since you're not charging you anything for it, and the general rule of thumb here is that if a product is free to you, you are the product. Okay, so the weather app is collecting, where you are. It's at 7 o'clock in the morning when you share the weather. They're saving that data and they're selling it to a broker that is basically mapping those geo-coordinates to addresses. So what Charlie can do is he sends your file to the vendor, and they arrange to send ads to all of the devices that spend the night at the addresses in your file. So I'm pretty sure that there are lots of people out there in the online advertising agency that are reverse engineering the location of the data. So your phone is only identified by a device ID and advertising IDs established by Apple and Google. But if you can tie this device to an address and then use public information to tie through that address to a person or a household, that's one way you get a lot of extra creepy ads. And that's why I've defined the address as precise geolocation is information that is accurate enough to define it, to determine your address.
Thank you, Representative Elkins. Any other comments? Any other questions? Representative Niska.
Thank you, Chair Westland. Thank you, Representative Elkins, for your work on this. I wanted to pick up right on that last point, and two of the, I think, it sounds like open questions are what to do about that geolocation definition and also the pseudonymous information. The scenario you're talking about gets right at that core question. I'm curious about your thoughts on how to do that in a way that also advances, like you were saying, the interest in trying to make sure that we're as aligned as possible with other states to try to make it as easy as possible to comply with, multiple states' regimes at the same time.
Thank you, Representatives and Madam Chair. I think it's interesting. One of the novel provisions in my bill is one that prevents third parties from trying to re-identify pseudonymous or de-identified data. And nobody has complained about the fact that I put that in there. And I think it's because most people who are interested in doing that are too embarrassed to admit that they're doing that. So I mean, if you just look at this online and thumb through it, you'll see that no two bills, I mean, there are 12 to 14 of these out there, no two are identical. If nothing else, one of the things you'll notice just by leafing through this is that just the bill drafting conventions from state to state are very, very different. In Connecticut, the way Connecticut and Colorado draft their bills is completely different than ours. So there are no two bills out there that are going to be exactly identical. I'm trying to substantively, stay as close to the general model as possible. But there are a few things that I know just from being an information architect in IT for 25 years, managing and modeling data. There are things that I, as a 25-year information architect, I think that are really, really important that I'm not going to leave out of my bill just because, the 11 previous states didn't have an information architect on their staff to point these things out. So a good example of something I put in the assessment section was a requirement that a company show how they inventory their data. Okay. There was a story in Wired magazine about a year ago about a period in Amazon's history, and the people at Amazon assure me that this was a brief point in time, and those problems are solved. But they hired a guy to be their chief information security officer, and he really realized that he was in over his head because there's no way he was going to be able to do his job because the business side of Amazon did not have an inventory of its data. He had no way of knowing what he needed to protect because there was no inventory. And whether that was true or not, it should never be true. And so I put that into the assessment section of my bill, even though it's not anywhere else, that you need to know your data. So I tried to be, very judicious about where I added new things. But other states have innovated as well. Like I said, I'm taking Texas's definition of a small business. It makes sense. The business community likes it. I'm looking at Oregon's provisions for around Graham-Leach-Bliley, though Mrs. Cook, if she's still here, had an even better idea that I may work with instead. But every legislator that I've talked to has had a bill that passed, has regrets about how they worded their Graham-Leach-Bliley exemption. So. Yeah.
Any other questions? Anyone online have questions? Representative Scott?
Thank you, Madam Chair. And who says that data practices isn't fun? I mean, you can't get more into the weeds than with this bill right here.
Yeah, Representative Scott, when I took this on in 2019, it was what I learned later that it was the first draft of Washington Senator Reuben Carlisle's bill, and I only took it basically the Microsoft lobbyist was shopping it as a template. And I said, well, I told Amos Briggs, and I told him, Amos, I can't promise I'm going to try and pass this bill, but since I spent 25 years managing data, I'm probably the logical person to take this on. I had no idea what a rabbit hole I was diving down.
Yeah, I can't imagine a lot of moving parts. And one of the questions that I had, and Representative Lucero kind of hit on it, but, and I understand, Senator Lucero, he's not here to even correct me, so. And I understand now your explanation and just trying to line up definitions with what other states are doing, and that makes a lot of sense to me. I was just going to ask about the biometric data definition, because we just came up with kind of a biometric data definition last year when we did the genetic testing, that whole bill. And so I don't have did you look at that definition at all?
Yeah, so Madam Chair, I think the way that the biometric definition and these bills is written the way it is because, there's all kinds of audio and visual data about us that's just out there in the wild. And there's not really any way to, kind of charge a company that may have access to all of this information out in the wild, expecting them to protect it in some manner.
Yeah.
It's like them cows are already out of the barn.
Yeah, I understand. Madam Chair, and I just, as I'm listening to all you present the bill and listening to the testifiers and so forth, I just can't help but think of the fact that we've had this thing called the Minnesota Health Records Act for how long? And this is the kind of thing that providers are supposed to be doing. They're supposed to be giving people, these choices and these opt-outs instead of just saying, here's your HIPAA form, take it or leave it. So that goes to the piece of if we can't even enforce that in a proper way and get the providers to do what they're supposed to for the consumers, this is so much more encompassing. And so I just want to put that out there as a comparison, that this is a gigantic undertaking. Thank you, Madam Chair.
Yeah, Madam Chair.
And Representative Elkins, I'll let you go ahead and answer that, but then I also do want to, Senator Limmer did have a question or a comment, so I want to make sure we get to him
Let me
as well.
respond to this one, and then we can do that. So one of the things I'd kind of like to take on is an interim project for next summer is go back and look at the Minnesota Health Records Act and bring it up to date and fold it into this framework. It's been around a while, and the last time I read through it, one of the things that struck me about it were that it's from like the pre-computer age, and it seems to presume by the way things are written that everything's on paper. So it talks about copies of documents and signed on paper, and it needs to be brought out of the paper age and into this kind of a framework, because with respect to my health records, they're all electronic now, and as you were observing, my expectation, and it's not, I can't realize it under the Minnesota Health Records Act as the way it's worded right now, is I expect to be able to go in for my health data like anything else and be able to reset my privacy settings, preferences.
Thank you. Go ahead, Senator Limmer.
Well, thanks. I've been listening attentively to our discussion. It kind of brings me back to a lot of early data privacy discussions we've had in the legislature over the years. We used to have a subcommittee on data privacy in the Minnesota Senate, as did the House. And I think for the most part, most legislators' eyes roll over and glaze over, and they don't want to even talk about data privacy, but it's vitally important that we do, and this type of discussion really is necessary. I did want to make an observation. There's been a lot of discussion about proposals that we've heard today, and then how these current proposals are compared to other states. Well, let's just keep in mind that there's very powerful lobbyists out there that have over the many years in many states been more successful at writing bills than others. And I would also say other privacy advocates have been more successful in other states. But nevertheless, Minnesota has always prided itself on being a very unique state where we protect the privacy rights and private information of our citizens a little bit more than any other state in the country. And I hope we can continue doing that. It is, as this bill reflects, it can get into a lot of complex rabbit trails that we can go down. But nevertheless, it's vitally important. I condemn the author on attempting to bring this forward. I think it's timely. I think it's something that we've got to continue to develop and keep that discipline so that legislators aren't caught off guard. Now or in the future, we have to maintain this discipline. And the only way you do it is going through exercises like this. Oftentimes, chairs of committees don't want to tie up the time, especially in recent times when we've only had 1 minute testifying going on committee hearings. A 1 minute testimony is not adequate for a bill like this. So hence the need for our commission, but nevertheless, these take really careful reads, and one has to really kind of put on your dark side imaginations of how certain definitions could be abused. And not to say that this bill has that in any way. It's just that as we look at proposals and as we look at other advocates bringing counter proposals or suggestions, it's important for us to really be carefully analytical in how we do this if we want to continue to be a state that protects the rights of our citizens and at the same time keep government as open as possible so the citizens know what government is doing either for them or to them. That's all I want to give any advice on right now, but I've been listening carefully to the discussion. I appreciate it.
Thank you, Senator.
Thank you, Senator Limmer. I appreciate that. It is a few minutes after 3. Representative
Just wrap it
Elkins,
up.
if you have any final comments for us today, otherwise I will go ahead and
Yep.
wrap up, but go ahead.
Thank you,
if have
Madam
some.
Chair. Yeah, so I've been meeting with stakeholders on an average of about 2 a day for the last couple of weeks. It continues. So I met with the consumer reports people on Friday, and the business community had a meeting with the chamber, the business partnership, NFIB, and the retailers last week. And I think we're at a point. I mean, I think you see it reflected in the letters that they've submitted that we're very close. We're down to fine-tuning the language, and so my drafter is Nathan Hopkins in House Research. He's doing an amazing job. It's a very difficult job to do, but I fully expect that by the time this is heard in the House Commerce Committee early in the session, that I will have achieved peace in the Valley.
Well, that ain't easy. Thank you so much, Representative Elkins. Thank you for everyone who has participated today. I just want to issue the reminder, we will be having our final pre-session meeting on February 6th. I hope everyone is able to attend. I know Senator Lucero, see what you started. Senator Lucero is probably going to ask us to hear a bill. Representative Feist, I know you had a couple of items of interest. If anybody else has anything that they would like us to attend to at that meeting, please get that to staff right away. And I think the intention would be to sort of have a conversation amongst ourselves about whether there are any items that we've heard that we want to either make recommendations, not make recommendations, what action we want to take, if any. And so I hope everyone can attend on February the 6th. And then we can discuss also at that meeting sort of maybe a post-session. I know there were a number of broader topics of discussion that weren't necessarily specific bills. So I'd like to start talking about meeting after session ends. I know nobody wants to come back, but I also do want to make sure that we have an opportunity to have some topical and some informational meetings following session. But I do appreciate everyone's being here today and participating. Thank you, Representative Niska and Representative Elkins, for presenting your bills today. And with that, we're adjourned.
Thank you.